benefits. My name is Shannon Drake-Burr, and I'm with the Wisconsin Primary Healthcare Association. We're going to get started in about 2 minutes. I see lots of attendees still coming in, so just sit tight, and we will start soon. Public benefits. My name is Shannon Drake-Burr. I'm from the Wisconsin Primary Healthcare Association. In the room with me, I have two fellow presenters, and I'll let them introduce themselves very briefly. First to Megan.
Good afternoon, everyone. My name is Megan Sprecher, and I'm the Immigration and Poverty Law Attorney with End Domestic Abuse Wisconsin.
And I'm Stephanie Sievers. I work for Covering Wisconsin, and I'm the Health Insurance Literacy Lead.
So we're so pleased to have you all on the webinar this afternoon, and we're going to go ahead and get started as we are at the top of the hour, although I do expect more people to join in the next 10 minutes. So I just want to give you all a little background on our collaboration. The Wisconsin Collaboration on Immigrants and Public Benefits came together relatively recently in February of this year to discuss the troubling and rising level of fear among immigrant clientele. So our aim and the bulk of our work has been to develop and circulate information to dispel myths in an attempt to reduce confusion and to promote the safety and value of accessing supportive, means-tested benefits for those who are eligible. So welcome to everyone who's still hopping on. We're going ahead and getting started with today's webinar on immigrants and public benefits. So our learning objectives for today are to build a basic understanding of the growing complexity around the intersection of immigration policy and public benefits, to help public benefit enrollment assisters learn how to screen individuals and families whose immigration status might be impacted by enrolling in public benefits, for example, Badger Care or Food Share, and then to help you all connect concerned individuals and families with reliable, free, or low-cost legal services. So to that end, we will be with you for about 90 minutes today, and we welcome your questions. If you have burning questions, oh, a little quiet, I will try to speak up. If you have burning questions or concerns, I guess not really, let's go with questions here. Please feel free to type them in the chat. We will have time at the end of today's presentation to address questions, and you can voice those over the phone. But if you have something that's top of the mind and you want to enter it in the chat, that would be great. That helps us track all the questions we have coming in. So our collaboration's guiding principles, and we felt that it was important to establish these, was that we understand and respect the fear and confusion and stress that many immigrant people are experiencing in the current climate. Also that circumstances change, and sometimes they change quickly. So both from the policy side, we're seeing lots of changes in policy, and then also individual family circumstances change. And so we need to be cognizant of changes on both sides. And that our aim is to empower individuals to make informed decisions using public benefits, and with that to respect the decision they made. And I just want to put a call out there that if you're listening on today's webinar, you could, we're getting a little background noise that can be helpful so that everyone can hear the presentation clearly. So go ahead and mute your phones. We'll take strategic breaks for questions. You can also type your questions in the chat. So thanks for muting. So we are going to start with a very quick review of healthcare benefits that are available to immigrants, just to sort of root ourselves in talking about when we talk about public benefits with a focus on healthcare benefits, as a large share of the people joining today's presentation are working at healthcare-oriented organizations. So I'll hand it off to Stephanie to talk through benefits.
Okay, so first we wanted to establish clearly what are public benefits. Those are government programs for people who have low income, and they can help with food, housing, cash, or health care. So one important part of this to keep in mind is that these are means-tested programs. So that is most often defined as mandatory spending programs in which the eligibility for the program benefit, the amount of such benefits, or both are determined on the basis of income, resources, or financial needs of the individual, household, or family unit seeking benefit. So if you want to just simplify that in your mind, just think means tested is really looking at some type of test to see if somebody meets a low income or needs-based test.
And I'm sorry if the presentation was a little small. Can someone confirm that they can see better?
Yes, it's in full screen now.
Okay, I'm sorry about that.
Okay, and two types of, I should talk, so specifically we want to talk about healthcare benefits. So programs for qualifying immigrants, that's predominantly going to be Medicaid, and you have to be a U.S. citizen or qualifying immigrant, and there's some exceptions to that. So permanent residents under the age of 19 who have been a permanent resident for 5 or more years. And then we have programs available for immigrants regardless of status. So you can be undocumented or have any immigration status and qualify as long as you meet the means-tested rule. So you meet some type of income requirement. So that's emergency services program. That's a part of Medicaid and prenatal services. Okay, and we have something else. If you're working in the healthcare field, we have financial assistance from the marketplace. I really want to make sure everyone walks away knowing in their minds that this is not considered a public benefit. So any type of premium tax credits or financial assistance from the health.gov or marketplace is not a benefit. So if you're not familiar with this, the premium tax credit, it lowers your monthly insurance premium. It's based on the income of the household and other household information. So size of the household and income predominantly. Okay, so one of the things we have heard out in the community is that sometimes when people are signing people up for benefits, they may be asking people for types of documentation that we want to really avoid. So we just want to have a reminder, don't document the immigration status, patients, or consumers in electronic records or anywhere else. And if you have undocumented family members and they're using the number of the household, so if someone's applying for a program and you're using number of people in the household, but some of the people are undocumented, please don't share their immigration status or social security number or anything of that nature on applications for any type of public benefits such as food, health care, and also at the community health centers for any sliding scale fees. We want to avoid documenting any type of immigration status. Okay, so we're going to, Megan, talk about the current state of rules.
Okay, so we're going to talk about public charge, and we'll start with what is it? You've probably been hearing a lot about it, maybe in the news, maybe from patients or clients that are coming in with concerns. Public charge is something that's been present in immigration law for over 100 years. It's been something that's been constant in our immigration process in the United States. And it's defined as someone who the federal government determines likely to become primarily dependent on the for basic needs. And why does that matter? So if someone is considered public charge by the U.S. government, so by U.S. Citizenship and Immigration Services or the U.S. Department of State, that can impact their ability to get a visa to enter in the United States, get permanent residency or a green card, or change or renew their status. So it can really have a big impact on someone. So what we're really talking about today is if an immigrant or a family member of an immigrant uses a benefits program, will it impact their immigration status or options? That's the information that people are really questioning and worrying about now. So when does the public charge test apply? It applies when someone who's a non-U.S. citizen, an immigrant, enters the United States, when someone changes or renews their status, or when an immigrant applies for lawful permanent residency or a green card. There is not a public charge test when someone who already has their green card applies for naturalization. That is not part of the naturalization process or the process to become a U.S. citizen. So really what we're seeing is public charge impacts people who are immigrating through a family member. So someone who has a green card holder or a U.S. citizen family member who is going to petition for them. Those are the largest group of people who are impacted by a public charge. There are several groups of immigrants who are exempt from the public charge test. So that means that when they apply to change or renew their status, or when they're applying for their green card, they just are not subject to the public charge test at all. And it's important to note that the groups on this list, this couldn't change through the rulemaking process or through an executive order or anything like that. It would have to be an act of Congress. So several groups of immigrants who are exempt from the public charge rule, the current one and the new rule, are green card holders unless they leave the United States for more than 6 months, refugees or asylees, people with special immigrant juvenile status, and that's for youth who have been adjudicated abused, neglected, or abandoned, people with U or T visas. Those are types of humanitarian visas for people who have been the victim of serious crimes, including things like domestic abuse, human trafficking, people with Violence Against Women Act self-petitions, people who have relief under the Cuban Adjustment Act, the Nicaraguan and Central American Relief Act, and the Haitian Refugee Immigration Fairness Act. Certain special immigrant visa holders for Afghani or Iraqi nationals who help the U.S. Armed Forces with interpreting and other services. And then for the new public charge rule, members and families of the U.S. Armed Forces, Ready Reserve, or military serving in active duty are not subject to the public benefits portion of the public charge rule. So one thing that we want to talk about before we get started is the difference between something called adjustment of status and consular processing. So adjustment of status is the term that's used when someone is getting their green card from within the United States through an agency called the U.S. Citizenship and Immigration Services. And the main office that immigrants in Wisconsin go through for that process is the U.S. Citizenship and Immigration Services Milwaukee field office. Consular processing is obtaining a green card or other visa from outside the United States through a U.S. consulate. So for the immigrants in Wisconsin who are Mexican nationals, they would go through the U.S. Consulate General in Ciudad Juarez. So, when someone consular processes or adjusts status, it really depends on a variety of factors, including whether they currently live in the United States, how they entered the United States, if they're present in the United States, who petitioned for them, their current status, any past petitions that were filed for them. It really depends on a variety of factors, but there is a difference. This distinction is important, and we're making note of it because currently there are different public charge assessments made for consular processing versus adjusting status. So first I'll talk about consular processing, and again, that's where someone is obtaining their green card or other visa from outside the United States through a U.S. consulate. There were changes made to a document called the Foreign Affairs Manual in January of 2018. The Foreign Affairs Manual is what consular officers use to make their decisions. So in January of 2018, the U.S. Department of State revised certain sections of the Foreign Affairs Manual about public charge that dealt with criteria for evaluating a sponsor or a co-sponsor's affidavit of support. And a sponsor or a co-sponsor is someone who's filling out this affidavit of support saying, yes, I agree to maintain this immigrant if it ever becomes necessary in the future. It talks about the ability of consular officers to evaluate use of non-cash benefits by applicants, by sponsors, and by applicants and sponsors' family members in making a public charge determination. And in certain situations, applicants now need to provide proof of medical insurance or ability to pay medical expenses. The Foreign Affairs Manual also had changes that make it necessary in some situations for the applicant to show job skills, job history, and education as part of the public charge assessment. So the result is that between October 1st, 2018 and July 29th, 2019, the State Department denied 5,343 immigrant visa applications for Mexican nationals based on public charge. And when I say immigrant visa applications, that means applications for green cards. Immigrant visas are for green cards, and then non-immigrant visas are visas that do not have a path to citizenship in most cases. So just for some reference, only 7 immigrant visa applications for Mexican nationals were denied in fiscal year 2015. So the denial rate has gone up quite a bit. But public charge denial can be overcome. So sometimes, particularly in the past, if someone was denied based on public charge, often they would get another affidavit of support from a joint sponsor, and that would be enough to overcome the public charge denial. So the data so far shows that a little over 1,300 Mexican immigrants who applied in previous years were able to reverse a public charge determination during that October 1st, 2018 to July 29th, 2019 time period. We don't have data on exactly what these public charge denials involve. So, it could be more scrutiny of affidavits of support. It could be a number of things since the Foreign Affairs Manual contained a lot of changes. Now I'll talk a little bit about the current public charge rule for adjustment of status. So again, adjustment of status is applying for your green card from within the United States. It's in effect until October 15th, 2019. There are legal challenges to the new rule that we'll talk about a little bit later on in the presentation, but the old public charge rule for adjustment of status is in effect until at least October 15th of 2019. So this test looks at a totality of circumstances. It looks at age, it looks at health, family status, assets, resources, financial status, education, and skills. And as part of that financial status assessment, if you do not have a green card but use one of the following benefits, it can be a negative factor for your public charge assessment if you're adjusting within the United States. So that would be use of W-2 cash assistance, long-term care institutionalization at government expense, or supplemental security income, SSI, which is a cash assistance for people who have disabilities and also very, very low income and little or no work history. So in Wisconsin, sometimes people don't know if they get SSI or SSD. So one way to make it easier to tell is that someone in Wisconsin who receives SSI would get a monthly state payment of $83.35 for an individual or $102.05 for a married couple. So under the current public charge rule for adjustment of status, these would be the only public benefits that would make someone be a negative factor in that totality of the circumstances test. Under the current rule, if someone in the household, not the applicant, gets W-2 or SSI and it's the family's only income, that could also be a negative factor in that totality of the circumstances. Other than that, it's only looking at the applicant themselves of public benefits, and it's only the W-2, the long-term care, institutionalization, or SSI. And then the affidavit of support has a lot of weight under the current rule, and that, again, is something that's submitted by the sponsor and a co-sponsor if the sponsor's income or assets are not high enough. So the new public charge rule was issued through the U.S. Department of Homeland Security, so it would impact adjustment of status. So again, applications for green cards from within the United States, and then any applications to change or extend status from within the United States. It applies to applications submitted on or after October 15th. And like I said, there are legal challenges. We'll get into it a little bit. There's a new definition of what it means to be a public charge. It still is a totality of the circumstances assessment, but it has new weighted factors, and it's really designed to make it really difficult for low-income and middle-income immigrants to be able to enter the United States. It does include additional benefits programs that USCIS can consider in that totality of the circumstances assessment. So the new definition of public charge is someone who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period, so within a 3-year period. And if you get 2 public benefits in 1 month, that would count as 2 months. So if under public charge, it is a forward-looking test. So if the government determines that someone is likely at any time to become a public charge in the future, it can deny someone admission to the United States, it can deny them a visa, a green card. So what it's looking at, the new rule is the government is looking at, is this person likely in the future to receive 1 or more public benefits for more than 12 months in the aggregate within any 36-month period. So again, this is forward-looking. So it is a little bit confusing, I think, with this new definition. I think a lot of people are thinking, well, if I haven't received 1 or more public benefits for more than 12 months in a 36-month period, I'm fine. But it's really a forward-looking test looking at if someone is likely to receive that number of benefits in that time period. So again, there's still the totality of the circumstances test. So USCIS is going to consider age, assets, income, resources, health, work, skills, education, family, affidavit of support, and public benefit use. For public benefits use, consider the number and type of benefits used, the length of use, and how recent the use was. So this slide talks about the additional benefits that are under consideration under the new rule. So you can see for what's always been the rule, it's still included. So cash assistance, long-term institutional care, and under the new rule, which is set to take effect October 15th, food share or SNAP would also be included. Medicaid with certain exceptions, so it would not be included if a child under 21 received Medicaid, and it would not be included or assessed if a pregnant woman received Medicaid up until 60 days postpartum. Housing assistance, public housing or Section 8 is included included in the new rule. So this is a list of various benefits programs that are still really important to families that are not included in the new rule. So I just want to point out again, Medicaid is not included in the new rule for kids under 21 or pregnant women up until 60 days postpartum. And then the other benefits programs listed on this slide are not included in the new rule. So like I said, there have been several lawsuits filed. There are at least 6 federal lawsuits that have been filed, and a couple have requested a delay of implementation or a nationwide injunction, which would an injunction would temporarily stop the implementation of the rule until a decision was made on the lawsuit. So we'll know more about that in early October. There are hearings on those requests on October 2nd and October 3rd, and we'll know more at that point about whether the new rule will actually take effect on October 15th. Something that's important to tell families is that the new rule is not in effect yet. So it applies only to applications submitted on or after October 15th, 2019. And that newly named benefits like food share, like Medicaid for non-pregnant adults that are used prior to that date will not be considered. It's also really important to communicate to the community that not everyone is subject to the rule. A lot of immigrants are exempt from the public charge assessment, and that under the new DHS public charge rule, which applies to people processing from within the United States, benefits used by family members will not be counted. And that it is a totality of the circumstances test, so positive factors can be weighed against negative factors, and it's a forward-looking test. And this is something where every situation is different. It's not something where we can give cookie-cutter answers, and so consulting with an immigration attorney with questions about a case is definitely appropriate. And this is a slide from the Protecting Immigrant Families campaign, and it talks about, all the different things that immigrant families, especially low and middle income immigrant families, are facing these days, and really how overwhelming it feels, and how scary just everything, the cumulative effect of all of this feels for immigrant families. So what we're hearing, what we're seeing in the community is that families are unenrolling or not enrolling in public benefits. There's confusion over the new rule versus the Foreign Affairs Manual changes and the 2 different rules. I will say that under the new DHS public charge rule, it did have a section at the very end that talked about working, the Department of Homeland Security working with the Department of State so that the Foreign Affairs Manual would reflect the new DHS rule. That hasn't happened yet, so there are 2 different rules right now. People are fearful about disclosing personal information in getting benefits and getting health care, and are afraid that that is going to come back and be communicated to ICE. And a lot of families are making decisions about their benefits without knowing exactly what the rules are and which one applies to them, and we just really want to make sure that people have all of the information they need before making those big decisions. So who has the expertise to help? Legal experts who work with low-income populations are especially, I think, qualified to address this issue. Some immigration attorneys who are not used to working with low-income families are not as familiar with public benefits, with the nuances of public charge, and sometimes err on the side of caution. And it's okay to get a second opinion. So even someone who has an immigration attorney, if they want, they can get a second opinion. And then that second attorney is actually prohibited by the rules of professional conduct for attorneys from telling the first attorney about the consult without that client's permission.
Okay, so now we'll hand it over to Stephanie to walk through this guide to help guide your conversations with people who come into your health center or agency with questions about their use of public benefits and the impact it may or may not have on their immigration status.
Okay, thank you. So we developed this guide for professionals, enrollment assisters, and anyone who works at any type of community organization to help guide you in your conversation. So we just want to stress that while we tried to make it user-friendly, we don't recommend that you pass it out to people, and we will have more documents coming that you can hand out. So one of the reasons I say that is because we don't want to create unnecessary fear in the community, and so we'll develop other types of resources that will be more appropriate. So before you use the guide, it's really important to remember how stressful this particular moment might be for someone who's an immigrant or for their family. And so when people are in moments where they feel fear or stress, they're likely going to struggle to understand policy or how it might affect them. And this is just something that happens to all of us. Think about if you're at the doctor and you're worried about what the doctor's prognosis of your health might be, you may not hear the words they tell you, and this is just a natural response. So to try to mitigate that effect and to really help people understand, remember to use everyday language, explain your jargon, enunciate, go slowly, repeat, summarize often, and keep asking questions as you go. And I highly recommend you ask information questions and not yes or no questions. So the first thing we want to do is make sure that whoever you're talking with is not in the, what we like to call the safe list. So anyone who is on this list can safely use public benefits without a negative consequence to the immigration status. And the only time where it could have a negative effect is if they want to bring someone over to the United States or sponsor them. So in general, if someone is on this list, it's really important that we communicate clearly that they can safely use public benefits without any negative consequence, and just stress, if you want to petition a family member, then you could have it could have a negative consequence. But again, as Megan said, one use of a public benefit is not necessarily going to be a determining factor. Okay, and then as we know that there's two types of processes, there's either the consular processing or processing within the United States. So we have to figure out where people are at. So if they're inside the U.S., or they're going to process, from inside the U.S., then the only public benefit use that could have a negative consequence is in this following list here. So we've got Badger Care Plus, but except, remember that's really important, except anyone under age 21, to use emergency services for both adults and children, or care for pregnant women until 60 days after the birth of the baby. So that's the first one. That's sort of the Medicaid list. And then we've got housing assistance from public housing or Section 8, food assistance from food share, and people often tend to call this by different names. They might call it food stamps, Quest, or EBT, any type of cash maintenance benefits, such as Wisconsin Works or supplemental security income. And then lastly, the assisted living nursing home or home care paid for by Medicaid long-term care program. So those are the only things or only public benefits that are on the list, and all the other benefits most immigrants who are going to process inside the U.S. can safely use. And so some of the future documents that we're going to prepare to give out into the community will have a larger list of what people can use. Because we find when we give people a list of what they can't use, they keep asking, well, what about this program? What about this program? And so we're going to create those documents. And then, just remind people that any use of these benefits doesn't necessarily automatically make them, is going to mean that they'll become a public charge, right? They're going to look at age, assets, income, health, family, work, skills, and education, public benefit use, and the affidavit of support. So using one or two of these benefits is not necessarily going to affect them. So for people who have to apply from outside the U.S., and you may not be able to easily determine that, and they may need to seek legal help to try to figure out if they will process within or outside the United States. The U.S. consulates outside the U.S. tend to use stricter rules, as Megan talked about. So if you use public benefits and you plan to apply for a green card, sponsor or co-sponsor an immigrant, apply for entry to the U.S. or renew your status, it may be advisable to talk to a lawyer. So that's the case where someone's sitting with you and they're not sure. You might want to direct them to a lawyer, and Megan will talk about that. Or next.
Okay, so we're going to talk about legal referrals now. So some situations where it would be a great idea to give someone information about how they can talk to a free or a low-cost qualified attorney or accredited representative would be someone who's confused about something that an immigration attorney told them in the past, someone who has doubts or further questions, someone who doesn't know if they would need to use consular office to process or whether they could adjust status in the United States, someone who answers yes to some of our screening questions, and then someone who doesn't understand their current status or a loved one's status. All of those situations would be totally appropriate situations to make a referral to an attorney or a qualified representative. So an attorney could help someone understand how each part of the public charge test could affect the family. It's complicated, especially under the new rule, and so an immigration attorney who has experience representing low-income people especially has the skills and expertise to make those assessments and recommendations. An attorney can also assess someone to see if they're eligible for immigration relief. And you know, at a lot of these brief advice clinics, there are always people that come in that didn't know that they were eligible for a certain type of immigration relief. And so seeing an attorney can help someone find out that they might be eligible for something when they didn't think they had any form of immigration relief possible. Information shared with a lawyer is confidential, and as I mentioned previously, you can always get a second opinion. This is a slide that has more information about the new totality of the circumstances test under the new DHS rule, which is set to go into effect October 15th. You can see with the one green arrow up, it means it's a positive factor. 2 green arrows up is a heavily positive factor. 1 red arrow down is a negative factor, and 2 red arrows down is a heavily negative factor. So as you can see, it's complicated, and it's something where it's really best to leave it up to an immigration attorney or a qualified legal representative to give families advice about the public charge test. We did put together a list of free and low-cost legal services, and these are all organizations that are very used to working with low-income and middle-income families. So there's a section of the list that has free services listed. Each of the organizations has their own criteria. Some have certain grants where they are able to provide free services to people that fall under those grants, and then have no charge or have a sliding fee scale for the rest of the people.
And I just want to point out, this is a separate handout. It's also, it was in the webinar email that went out with the link, and it's also on our website. And it's in Spanish and in English.
And then we also have a low-cost section, and several of the organizations do have a consultation fee, but the ones where it says, like, for example, the Catholic Multicultural Center Madison, 0 to 50, Organizations like that said that they do have a consultation fee, but if someone truly cannot pay their consultation fee, they don't turn people away. Legal Action of Wisconsin is able to answer questions related to immigrant eligibility for benefits based on the current rules, or if an immigrant has a denial, a reduction, a termination, accusation of fraud, overpayment, or any other violation for their usage or the child's usage of a public benefits in Wisconsin. And we included their intake number, and then there's a special number for farm workers. So the farm workers, that's statewide. So how can you make a good legal referral? Help the person identify what their legal question is. What is the primary question that they're looking to answer, and what is their goal in talking to the attorney? So it could be a couple of things. It could be, am I eligible for any type of immigration relief? Would I have to adjust status or consular process to get my green card? Is my child using Badger Care going to impact our family's immigration status? And secondly, help them collect any paperwork related to the legal question. So immigration documents, public benefits applications, reports or records of any public benefits received, and any letters received from the benefits agency. Helping them sort through that and figure out what would be helpful for an immigration attorney to see, to be able to help them. And then the individual will have to complete the agency's intake process. So it's something where they won't probably get an answer immediately. It's something where they would have to go through the agency's intake process. And then the agency would be able to say, yes, I'm able to help you with this issue, or no, I'm not able to. So the person might have to contact more than one agency before being seen in some situations. And managing the person's expectations. So like I said, each organization has their own eligibility guidelines and restrictions. They might have to wait for their case to be assessed or accepted before they'll get information, and to not make promises about what the attorney can do. And it's a great idea to develop relationships with the referral sources in your area so that you understand what services they provide, what their capacity is. Are they doing brief advice? Are they doing extended representation? And then that'll make the referral process easier for you to better explain to your clients and patients what the process is and what they can expect. And we'll keep our website updated, and then also the Protecting Immigrant Families has a website as well as a national organization.
Thanks so much, Megan. That was all really helpful. So I know that this can be a hard conversation for you all to have with families, and sometimes you feel a little bit like there's not a lot you can do, but there are some really essential things you can do. And that we're asking you to do. So we're asking you to empower people with knowledge to make decisions. So rather than having people make fear-based decisions based on rumors or things they, heard from a friend or conclusions they arrived at, without a lot of information, to share information with them to empower them to make a knowledgeable decision. We also, want everyone to honor the decisions that individuals and families make, and just remind you all that a decision made today, if somebody chooses to enroll in a benefit, they could come back tomorrow and choose to unenroll, or they could say, I don't want to enroll today, which I know sometimes if you're a public benefits enrollment assister and the bulk of your work is helping people make connections to important and valuable resources, and they decline to do so even though they're eligible, that can be frustrating, but you can encourage them that if something changes, if they want to revisit that decision, to come back, and you will still be there to help them revisit that choice. We want you to help connect people with the legal help they need. So we know, and we've heard from a lot of people, that when the conversation goes to, I think you should talk to a lawyer, that a lot of people just step away at that point and they don't make that next step of actually talking to a lawyer. And so as warm of a handoff as you can make, if that's the recommendation, if you're looking at the guide and there are questions that you cannot address as a public benefits enrollment assessor and not an attorney probably shouldn't address, they do help make the case as to why it would be valuable for them to get some legal advice about this situation and help them to do so. And then to share any stories you have. There's a research project going on right now by the National Immigration Law Center. You completed the survey, I think, as part of your registration for this webinar today. So we share that information, just anonymous, aggregated, non-identifiable information with some national partners that we have, the Protecting Immigrant Families campaign, just to have some good information about what people are saying, what people are hearing, and how communities are being impacted. So we thank you for contributing to that survey. So we've got plenty of time to address questions, and we would be happy to take them either in the chat or by voice. If you have a question and you've muted yourself, I'm just going to remind you that you will have to unmute yourself to ask a question. So please let us know what your questions are.
Hello, can you hear me?
Yes.
Hi, my name is Francisco. I'm coming from the Bridge Clinic in Wausau.
Hi, Francisco.
And hi, and the question I have, so I have a permanent resident that is wondering if she needs to drop her Medicaid because she's afraid of being charged for it. She's currently not working, but if she's a resident for like many years now, she shouldn't be worried about, right?
So thanks so much for that question. This is Megan. So someone who already has their green card is not subject to the public charge test. You know, I will say if someone has been a green card holder for 5 years or more, they would be able to apply for U.S. citizenship in most cases, and that would be something that would be a good idea to look into. Currently, there's the public charge deportation rule for people who already have their green card is very, very limited. That's something where, you know, the U.S. Department of Justice is working on a proposed rule, kind of expanding the ways in which someone who already has their green card could be deported for public benefits use. But at this time, use of Medicaid for someone that has a green card would not impact them negatively.
Will impact her the fact that if she doesn't want to become a U.S. citizen and then she has to renew because she's been on Medicaid for so long, and at the end she's going to continue on Medicaid for the next couple of years, will affect her to renew her residency?
No. So someone who already has their green card and then is renewing their card or applying to become a U.S. citizen is not assessed for public charge.
Okay, thank you very much.
Thank you. Great question. Do we have more questions?
This is Greg. I see some by chat.
Okay. Oh, sorry. Do you see them?
Yeah. So from Tony, it says, could you go over again that benefits used by family members will not be counted? That is a topic that gets brought up a lot.
So under the new DHS public charge rule, which is set to take effect October 15th and applies to people adjusting status, applying for their green card, applying to renew or change their status from within the United States, it only looks at the applicant's benefits usage. It doesn't look at family members' usage. Under the current Foreign Affairs Manual section, which governs consular processing. So, you know, having to go through a U.S. consulate abroad to get your green card or change or renew or apply for your status. The consular officers are able, they have the discretion to look at family members' benefits usage.
And that discretion is part of a larger, right, assessment, and so it's not a singular item.
Right, right. So the officer is able to look at the applicant's benefits usage, the sponsor's benefits usage, and their household members' benefits usage as part of a larger assessment.
Okay, I have another question from Anna. She wants to know if the green card holder is petitioning for a relative, if their use of public benefits will negatively impact the petition.
So if a green card holder is petitioning for someone, it would depend on whether that relative is adjusting status from within the United States or whether they are consular processing through a U.S. consulate abroad. So under the current public charge rule and then the one that's set to take effect October 15th for adjustment of status, so applying for your status from within the United States, the green card holder petitioner's usage of public benefits would not be taken into account. But if the relative would have to consular process, then the petitioner's benefits usage could be taken account as part of the larger assessment.
Okay, and somebody asked about a copy of the PowerPoint, and we will put the entire recorded PowerPoint on the website. Okay, and then I have another question that maybe Shannon can answer. We'll see. As an organization, if we have patients that apply for a sliding fee discount program and they turn in proof of income under a different name, so working under an assumed name, how should we handle that as a clinic? What is our obligation?
You know, I would reflect your clinic's policies around this, and I would just say, you know, we want to make sure people are feeling safe and not asking them to share more information than we need. So if they can share the information, the minimum amount of information that you need to apply the sliding fee scale determination to allow them to use services via a sliding fee scale, that you do that, and that you just try to keep your policies as open as they can be, and just not demand additional information that's really not necessary. And we can chat about that more offline. That's a question that's probably pretty specific to community health centers, so I'm happy to explore it further.
Okay, I have another question from Janet. Where does child care assistance fall in the public benefits criteria?
So child care assistance is not included under the current public charge rule that's in effect until October 15th, and it's not included in the new DHS rule, which is set to go into effect October 15th. So for people who are adjusting status or applying to renew or change their status from within the United States, it's not going to be taken into consideration. Could potentially be taken into account for people who are consular processing if the applicant or their sponsor or household members receive it.
Okay, and then I have a question from Renee. It says, you mentioned earlier applications were denied, but how many were submitted? I don't know if we have that data.
There are about between 70 and 80,000 applications for immigrant visas issued by the U.S. consulate in Cuba as far as each fiscal year.
From Janet, I heard, she said, Janet said, I heard there would be a minimum fee of $8,000 for those that are going to apply for residence. Have you heard of this?
So there, in part of the new rule is like a bond that you can pay in certain situations. So if you, if the officer determines that you are likely to become a public charge, in some situations you would be able to pay a bond to overcome that.
Okay, those are all the questions we have in the chat. Do we have anyone who'd like to pose a question over audio?
Oh. If a patient receives approval for Helping Hand, which is a charity service from a hospital, will that be considered a public charge when they apply for a green card?
I am not, this is Megan, I'm not familiar with that program. It's not on the list for the DHS rule, so it would not be, it's not taken into account right now or at post October 15th for adjustment of status, but I don't know if that would be considered a means tested benefit for consular processing.
It's maybe we can get clarity. It sounds like it's a charity program?
It's like a charity care program.
So yeah, a private charity care.
It is on the list of the document we prepared for the community. Right now it's we haven't publicly released it yet. It's being consumer tested. It's on the list for programs that are not counted.
I was just going back to see if I could find it, but probably more distracting than anything else. Sorry.
So here's another question. Is there an action concern present if an undocumented individual receives services or assistance from an FQHC? Say that again. It's federally qualified health clinic. So is there a real concern for someone who's undocumented if they get services from a federally qualified health clinic? No. No, there is not. Again, though people, because of the climate, they might be afraid, it's very important that the people who work in the clinics do not ask for immigration status,
right,
even if the application has that question on there. Or if people choose, if you ask, if people choose not to respond, then we accept that answer.
Did everyone hear that question okay? Because I think we were on mute for part of it. So that was about undocumented people using services at federally qualified health centers, and if there are concerns around that, and no, federally qualified health centers are able and should, serve everyone regardless of their immigration status.
Okay, and then there's a question about a specific program called Ryan White. Is there any effect on that program? Will someone be considered a public charge if they use that program?
Ryan White is not, that's a program for people with HIV and AIDS, and this is a program that was not explicitly mentioned in the public charge rule, so it's not included. So for those people who are processing within the United States, it's not a program that will be considered.
And if you have any additional questions, feel free to type them into the chat or unmute yourself.
So one question we heard a few times in previous presentations was, does the final public charge rule include exclusions for SNAP, or also known as food share, similar to the Medicaid exclusions for children? So if we remember, Medicaid, use of Medicaid in Wisconsin known as Badger Care Plus, for people under the age of 21 is excluded. There is not the equivalent exclusion for SNAP or food share. And so if the child, him or herself, is the person who would be adjusting status, that could be included as one negative factor in the public charge assessment. And again, that would just be one factor among many. Use of food share, isn't automatically a determination, doesn't automatically result in a public charge determination.
And just wanted to add, SNAP is included, it's true, but there's several programs that also provide food that are not included under the public charge listing. So WIC, and people can use food pantries,
School meals.
So there are still several programs that involve food assistance that were not listed. So I have a few more questions here. Will the Wisconsin Well Woman program count as public charge? I do believe that's funded under Medicaid.
Yeah, so that would be considered Medicaid. So it would count unless the person was under 21 or pregnant up till 60 days postpartum, or under the DHS rule for adjustment status.
Okay. So there's an acronym in the next question, so we may not know it, but it says we use PAP, a medicine program that requires a denial letter from Badger Care Plus if the person had a social in the system, I assume a social security number, which was not theirs. Would the person be affected? Yeah, so that was from Evangelista. Evangelista, we might need more clarification. If you want to unmute.
It sounds to me like, you know, if this isn't a program that's administered by the state, it's not part of Medicaid, it's not part of Badger Care, anything not listed in the final rule on public charge, again, for people who are processing or adjusting status within the United States, is not counted. So this isn't part of Wisconsin's larger Medicaid programming, then it's.
But if the person needs a denial letter, they would have had to have submitted an application.
Yeah, so the application to Badger Care would be considered a negative factor for the new public charge rule, but the actual usage of the PAP, you know, if it's not on the list, if it's not considered Medicaid, then that would be a negative factor for adjustment status.
So this other question, I'm not sure if we can answer it. What about the program 340B for medication? Yeah, we're not sure who funds it. We're less familiar with that one.
That's the discount medicine program that's available for discount medications through health centers. That's a good question. It's not funded by Medicaid. It's a different program, and it was not included in the final rule. So I can follow up to the questioner in greater detail, and I'll consult with the California Primary Care Association. Has a lot of good specific answers to federally qualified health center questions, and I suspect that they have an answer to that question. But if it's not on the list and it's not funded by Medicaid, then it's not included for those who are processing adjusting status within the United States.
Okay, and I think we're at the end of the questions, unless a new one came in. Oh, okay, I think I have another one here. Will someone be affected if they apply for Badger Care Plus being undocumented? They will get denied and unable to use services, but will they be affected because they applied for it?
And under the new rule, an application is considered a negative factor as well. So application for one of the listed benefits or actual usage of the listed benefits are both negative factors under the new rule.
And I would just, you know, I know we've said this a few times, but we just want to reiterate that, you know, there are negative factors, there are positive factors, and, you know, so any one thing doesn't determine the outcome of these considerations. It's a multi-part, they call it a test. It's a multi-part test that looks, you know, at age, assets, income, health, family, work, skills, education, public benefit use, and application. And it looks at the sponsor's affidavit of support. So it's.
And I had some follow-up questions, Megan, to your answer. It seems that you weren't well heard. So if you can restate the last part about application.
So under the new DHS rule, which is set to take effect October 15th, and would cover people who are adjusting status or applying from within the United States, an application for one of the listed public benefits programs would be considered a negative factor, not just usage of one of the listed programs. So, and then what Shannon was saying is, just reminding people that it is a totality of the circumstances test, so it's not just looking at public benefits usage, but that's where, a referral to an attorney can really be helpful, because they can really look at the big picture and help people make decisions based on their whole circumstances that will be assessed.
And we want to remind enrollment assisters to go back always to that list of immigrants that are not part of this. So the naturalized citizens, the green card holders, with the exception of if they were to travel outside the U.S. for more than 6 months, and a lot of other protected immigration statuses that are related to humanitarian visas, including refugees and asylees. So always make your first question in having these conversations, start at, is the person before you, do they have one of the listed statuses?
And then someone asked about, again, the health centers. They wrote FHC, but I think they mean federally qualified health centers that provide medication and enroll a good number of immigrants. Will that count as a public charge?
If the medication isn't being paid for, by Medicaid, by Badger Care, it's not listed in the public charge rule, so it's not considered. It's not part of the assessment for those who are changing status within the United States, adjusting status within the United States. So it is a hard concept. I know that anything not listed is not included. And we've seen that when we've talked to potentially impacted people about just really wanting a list of programs that are safe to use. And so in our public-facing materials, we're trying to list out as many programs as we can, as we have space for. There are a lot of programs out there. I don't think we will ever reach a point where we have every single program listed. And so it's important to have that framework of anything not listed is not included for people who can change or apply for status from inside the United States. And then to know, and I'll pivot to Megan here, that for people who must change or apply for their status from outside the United States, also known as consular processing, that the rules are different, and they may want to talk to a lawyer to better understand the impact.
Right. So I think that the discretion that the consular officers have is just a lot greater in making public charge determinations at this point. So certainly referring people to free or low-cost immigration legal services providers would be a good idea.
So there was another question about the Well Woman, Wise Woman program. There is a Well Woman Medicaid, and then there's the Well Woman program, and I think we're going to have to explore a little bit more who funds that program and if it's counted. So I'm sorry if that's your burning question. We'll have to get back to you.
These are great questions. Are there more? If anyone has a question that they typed but we didn't answer, you might want to give it voice. Stephanie is working diligently to review all the questions, and if we missed one, it was not purposeful. So
somebody asked for the name of the speakers
I believe we have a slide with
yeah,
that in our contacts.
we sure do. So here we all are.
And somebody was saying potentially the Well Women program was funded by the CDC. If that's, we'll get back to you.
Yeah, we'll follow up on the questions we weren't able to answer with the people who asked, and maybe just a general email to all attendees of the webinar.
It's a great
they're good and important questions, and we will just dig into the details rather than provide a off-the-cuff response. Try to provide an informed one to you all.
I don't see any more questions in the chat box. I think I got them all, and I apologize if I missed yours. It's a very small screen.
It's a small box. So I just want to thank everyone who took the time to join us today. I want everyone to walk away, hopefully better informed than when we started. I want to acknowledge that the material is somewhat complex, and we encourage you to use the guide and sort of get comfortable with the guide to help you with your conversations. And then also to see Megan, Stephanie, myself, Shannon's contact information here. And please reach out if you want to have more conversations. Something I didn't share up front, and it was an omission, so I apologize, is that we are working on putting together a smaller slide deck, a more focused slide deck that you could, and we'll just post it to the Covering Wisconsin website under the Immigrant and Public Benefits category that you could use maybe at a staff meeting or to talk with colleagues at your agency or your health center to review the most important pieces of this change. And also, we do have these outstanding lawsuits, and we don't know at this juncture in time what the outcome of those will be, and they could impact when the new rule on public charge goes into effect. And then we also have the outstanding incongruities between the Foreign Affairs Manual, which has one public charge assessment, and the public charge rule, which has a different one. We may see changes to the Foreign Affairs Manual at some point in the future. And so there are still things evolving and changing, and we will continue to work on our documents. If things change, we will be doing additional webinars. We're trying our best to stay up to date.
I do have one other question. One last question I see here is, any thoughts on the Seal Smile dental program? Yeah, I don't know that we know enough about the program and how it's funded as to whether or not it's impacted. So we added it to our list.
Yeah, we'll add it to our list. I know the Seal a Smile program provides services in schools, and so it's providing services to kids. Kids are excluded if they're using Badger Care, and I know Badger Care is one insurance that's reimbursable to those school-based services. So, but children under 21 are excluded from the public charge test for use of Badger Care. So, so this, for those who are processing within the United States, should be fine. We'll explore in greater detail and share any additional updates to that. But that's an excellent point, and you all have brought up many programs that we clearly need to include on a list and get crystal clear on. So thank you.
All right. Thank you very much.
Thanks, everyone.
Thank you.